Welcome to Spoken Injustice, where we put the criminal justice system in the dock. In good traditional style, today we are taking a look back at some of the key moments of 2025 in the world of miscarriages of justice. From the restructuring of the Criminal Cases Review Commission to decades-old wrongful convictions like the Sullivan case, from the ongoing debate surrounding Lucy Letby to our contributions to national calls for evidence on computer evidence and private prosecutions. There is a great deal that could be said, but we will keep it brief. This is intended to be an easy discussion, an opportunity to reflect on what shaped 2025 and to look ahead to what 2026 may bring. 2025 will be remembered as a pivotal year in the struggle against miscarriages of justice in England and Wales. A year of reckoning, reform, resistance and renewed resolve. It was a year when long-standing failures were once again dragged into the light, when institutions were forced reluctantly to confront their own limitations, and when campaigners, lawyers, journalists, and those directly affected by injustice refused to be silenced. But 2025 wasn't just about exposing problems. It was about what comes next. The outcome of the CCRC inspection, the Law Commission's final report on criminal appeals, the government's response to proposals on sexual offences, and the ongoing heated debate around jury trial reform, so stubbornly defended by David Lammy. This is not just a review. It's a reminder of why these issues matter and why the fight for justice is far from over. So let's begin. One of the most significant developments of 2025 for our community was the restructuring of the Criminal Cases Review Commission, the body tasked with investigating potential miscarriages of justice and referring cases back to the Court of Appeal. For years, campaigners have raised concerns about the CCRC's culture, independence, and effectiveness. Accusations of excessive deference to the Court of Appeal, risk aversion, and a failure to properly investigate cases have become impossible to ignore. In 2025, those concerns finally triggered structural change. The restructuring was presented as a reset, new leadership arrangements, revised internal processes, and promises of greater transparency and accountability.
This is the hugely important organisation for our criminal justice system. Miscarriages of justice desolate the lives of the wrongly accused and they make the public less safe. It is very urgent that I should get on with both of these things.
How much of a mess is it in? Lord Garnier, the former Conservative Solicitor General, saying recently it's in a state of complete collapse. Is he right, do you think?
I haven't been. I start on Monday. I've looked at no fewer over the last decade than 4 inquiries, and all of them show very much the same problems. They seem incapable of learning from their mistakes. They are negative. They don't engage with the applicants. There is often a lack of understanding. They need to be bold. They need to be mission-driven. And none of it seems to apply. There is some inability to grasp the level of failure that is going on. I am very perturbed to find that they communicate very little with the applicants. How can one have, as it were, a client that you're driving the agenda for, that you're looking closely at, and not talk to them and not engage with appeal, for instance, in the case of Malkinson?
The language was optimistic, talking of restoring public confidence, learning lessons, and most importantly, putting applicants back at the center of the system. But restructuring alone does not guarantee reform. Many of those most affected by miscarriages of justice remain skeptical. Will the CCRC truly challenge and save convictions? Will it move away from its restrictive interpretation of the real possibility tests? Or will this prove to be little more than cosmetic change? As we move into 2026, the true impact of the restructuring remains to be seen. But one thing is no longer open to debate. 2025 marked the point at which denial could no longer be sustained. And the reasons for that are unmistakable. Few cases expose the human costs of systemic failure more brutally than the Peter Sullivan miscarriage of justice. A case stretching back decades, marked by evidential weaknesses, procedural failures, and repeated institutional refusals to confront the possibility of error. In 2025, the Sullivan case once again returned to public attention, not because the system sadly worked, but because persistence, advocacy, and scrutiny refused to let it fade into obscurity. The case shows a pattern we see time and again in miscarriages of justice. Early investigative failures followed by years, sometimes decades, of institutional defensiveness. Instead of asking the simple question, is this conviction actually safe? The focus shifts to how it can be defended. That has been the approach of both the CCRC and the Court of Appeal, and it's exactly why nothing has moved forward. What makes the Sullivan case so emblematic is not just the length of time involved, but the number of missed opportunities. Moments when intervention could have spared decades of injustice. We were reminded of a simple truth. Justice delayed is justice denied. And delay on this scale is not accidental. It is structural. The case continued to cast a long shadow over the criminal justice system in 2025. Coerced confessions, vulnerable defendants, the failure of safeguards. The case was no longer just about one individual. It became a lens through which broader systemic issues were examined. How does the system deal with vulnerable suspects? How easily can unreliable evidence become the foundation of a conviction? And how difficult is it to undo that damage once a verdict has been reached? What this case laid bare in 2025 is a hard reality the system still refused to confront. Learning lessons on paper is meaningless if nothing actually changes. The very same failures exposed in the Sullivan's case, how evidence is interpreted, how doubts are managed, and how institutions respond to challenge, are still playing out today, repackaged in new cases with new names. And it is for exactly that reason that no serious review of miscarriages of justice in 2025 can avoid the continuing, deeply polarising debate around the conviction of Lucy Letby. Throughout 2025, the Letby's case remained firmly in the public and professional consciousness, not because of new verdicts, but because of growing unease among sections of the legal, medical, and academic communities. What began as isolated questions has developed into a sustained debate about expert evidence, statistical reasoning, disclosure, and the limits of criminal trials when dealing with complex issues. At the heart of the concern is the way medical and statistical evidence was presented and understood, or misunderstood, I would say. Critics argue that patterns were inferred where alternative explanations were not fully explored, and that the adversarial process struggled to cope with highly specialized neonatal medicine. Supporters of the conviction, on the other hand, point to the jury verdicts and the appeals process as if that proves the convictions are safe. But really, it just highlights the same stubborn defensiveness and obduracy that has marked our criminal justice system for decades. What makes the Lucy Letby case so significant for miscarriages of justice is not simply the outcome, but what it reveals about the criminal justice system's ability, or rather inability, to handle complex scientific evidence. It raises uncomfortable questions. How juries assess expert evidence, how courts manage certainty, and how easily narrative can overtake nuance in high-profile cases. As 2025 came to a close, the debate had not settled. Instead, it intensified, moving beyond tabloid headlines into serious legal and academic discussions. This shift matters. History shows that many miscarriages of justice were once regarded as unassailable until sustained. Credible scrutiny made denial impossible. Looking ahead to 2026, attention will focus on whether fresh avenues emerge, further expert reviews, potential new evidence, or renewed engagement from the CCRC. Whether or not the convictions are ultimately revisited, and we believe they will be, the Letby case is already shaping wider conversations about expert evidence, disclosure, and safeguards in complex criminal trials, and those lessons will extend far beyond a single defendant. And while our focus remains on the courts, we cannot overlook the Supreme Court's pivotal role in shaping key aspects of criminal justice in 2025. One example comes from the Libor and Euribor cases of Tom Hayes and Carlo Palombo. Here, the Supreme Court demonstrated remarkable resolve in recognizing the failures of the Court of Appeal when it comes to handling errors of law. Its striking opening statement set the tone. The history of these two cases raises concerns about the effectiveness of the criminal appeal system in England and Wales in confronting legal error. While the final judgments were deeply disappointing for the specific cases, falling short of the closure they should have delivered, the recognition itself was a significant milestone. Having systemic errors acknowledged at the highest level sends a powerful message that reform is necessary, and we hope it will bolster ongoing efforts to restructure and strengthen the appeal system. The Supreme Court's influence did not stop there. In the cases of Dali and Keir, though arising under Scottish law, the court clarified a principle with broad relevance. The core purpose of a criminal trial is to protect the innocent from wrongful punishment. In particular, when dealing with sexual offences cases, the court rejected the blind exclusion of evidence aimed at understanding a complainant's behaviour. Instead, it emphasised that the privacy of the complainants must be carefully balanced against the defendant's right to a fair defence, a principle that reinforces the need for fairness and proportionality across all criminal trials. Taken together, these decisions show the Supreme Court stepping into confronting long-standing systemic issues, from recognising errors of law that were previously overlooked to ensuring that fundamental rights of both the defendants and complainants are properly balanced. They underline that reform is not just about technical rules. It is about upholding the integrity and fairness of the entire criminal justice system. But now let's shift focus for a moment. It's worth remembering that some of the most important developments in improving the criminal justice system don't come from courtrooms at all. They come from consultation rooms, policy discussions, calls for evidence, spaces where lived experience, expert knowledge, and careful scrutiny can shape reform before cases even reach a judge. This is where meaningful change often begins, and where our involvement becomes indispensable. Without informed contributions to these processes, the same failures are simply reproduced case after case under the guise of business as usual. 2025 saw us contributing to the call for evidence on computer evidence and private prosecutions, two areas now clearly linked to miscarriages of justice and brought into sharp focus by the Horizons inquiry. Computer evidence is often treated as inherently reliable, objective, and neutral, but as these cases show, these assumptions are deeply flawed. Software errors, misinterpretation of data, lack of disclosure, and an imbalance between prosecution and defence all create a fertile ground for injustice. Private prosecutions raise equally serious concerns, with fewer safeguards, limited disclosure obligations, and potential conflicts of interest. They risk bypassing the protections built into public prosecutions. Our submissions emphasised that these are not abstract risks. They are lived realities for defendants whose convictions rest on misunderstood technology or unchallenged and sometimes unchallengeable private evidence. The fact that these issues are now being formally examined marks progress. But of course, progress only matters if it leads to meaningful change. And another major focus of 2025 was the Law Commission's work on reforming the criminal appeal system, a system widely regarded as hostile to overturning wrongful convictions. The existing framework places extraordinary barriers in the way of appellants. The emphasis on finality, the restrictive interpretation of fresh evidence, and the reliance on the same courts that upheld the conviction all contribute to a system that resists correction. In 2025, the Law Commission's proposals signalled a willingness to rethink some of these fundamentals. For those working in the field of miscarriages of justice, these offered cautious hope tempered by years of experience. We were deeply grateful to Professor Julie Price and Dr. Dennis Eady for inviting us to Cardiff University for a full day of discussion on the proposed reforms. You can check out the video that was released in April. The event gave us the invaluable opportunity to engage directly with law commissioners, exploring the issues in depth and shaping our final response. Conversations were rich and dynamic, drawing on the perspectives of a diverse group: lawyers, academics, campaigners, justice advocates, and even survivors of miscarriages of justice. The day culminated in a deep and inspiring panel discussion that highlighted the stakes involved. The conclusion was clear. Appeal reform is not merely a technical exercise. It is a moral imperative. A justice system that fails to recognize and fix its own errors is weak, unstable, and unworthy of trust. Now let's look ahead. As we move beyond 2025, several key developments demand close attention. First, the outcome of the CCRC inspection expected in January. This will be a critical test of whether restructuring leads to real cultural and operational change, or whether long-standing criticisms remain unaddressed. Second, the Law Commission's final report on criminal appeals. Will it recommend bold reform or settle for incremental change? And crucially, how will the government respond? Third, the government's response to the Law Commission's proposals on sexual offences, an area where evidential rules, disclosure failures, and trial practices have profound implications for justice on all sides. And last but not least, the debate over jury trial reform. Despite mounting concerns about fairness, efficiency, and access to justice, David Lammy continues to defend the proposals with notable stubbornness.
Sir David.
The Justice Secretary quite rightly says that justice delayed is justice denied, but summary justice is no justice at all. And he based much of his argument on the views of the eminent Lord Leveson. But has he read the analysis of that review by Kenneth Rivlin, KC, who went through in great detail, and expert detail, the analysis and described much of it as unfounded and misguided because it's based on poor data. If he hasn't read it, will he please read it before he comes back to the House?
Can I say to the honourable gentleman that it was a serious independent panel, and I don't think you can sort of reject Sir Brian Leveson out of hand in that way. And I'd reminded that David Allmeron was also on the panel, and of course the analysis was based on data, based on evidence internationally, and that's why it's important that we implement it, because there is no silver bullet. To effect change, we have to do it all. Otherwise, at the next general election, the backlog will have soared to over 100,000.
Whether this position will hold in the face of systemic pressure remains an open question. If 2025 taught us anything, it is that miscarriages of justice are not anomalies. They are symptoms of deeper structural problems, problems that require courage, honesty, and sustained pressure to address. Change does not come from reports alone. It comes from persistence, from refusing to accept unsafe convictions as inevitable, from listening to those who have lived through injustice and believing them. As we look to the year ahead, the question is not whether reform is needed. The question is whether those in power are finally prepared to act. If you have made it thus far, thank you for watching. And thank you for continuing to stand up for justice. As we wrap up, on behalf of Barbara, myself, and everyone at Spoken in Justice, I want to wish you all a very happy Christmas and a peaceful, hopeful new year. May 2026 bring courage, clarity, and justice in all its forms. And remember, as Martin Luther King Jr. once said, the ultimate tragedy is not the oppression and cruelty by the bad people, but the silence over that by the good people. It is the courage to speak up, to challenge wrongs, and to seek truth that shapes a fairer world. Thank you for standing with us and for believing that change is possible. Join us again as we sit and rise in this unique trial.